A witness heard the victim scream a name before dying. The killer's name. But the jury never heard it. One legal rule, older than America itself, decides what evidence can convict and what must stay buried. 1978. Cleveland, Ohio. A woman named Sandra is found in her apartment. Before paramedics arrive, her neighbor hears her final words. She names her attacker. Clear as day. The neighbor tells police. The suspect is arrested. Open and shut case. But when trial begins, the prosecution hits an invisible wall. The judge rules that the neighbor cannot repeat what Sandra told her. Those dying words, the most crucial evidence, are banned from the courtroom. The jury never learns who Sandra named. And here is the question that will haunt you for the next 8 minutes. Why would any legal system silence a dying woman's truth? The answer traces back to 1700 England. Courtrooms were corrupt. Witnesses could be paid. Rumors manufactured. Defendants had no lawyers. No right to face their accusers. Wealthy men destroyed rivals with fabricated testimony. So Parliament created a rule. If you heard something from someone else, you cannot testify about it. Why? Because the original speaker is not in court. They cannot be questioned. They cannot be caught in lies. Their motives cannot be examined. If that sounds reasonable, drop a like, because here is where it gets complicated. This ancient protection designed for powdered wigs and quill pens now controls trials involving DNA evidence and cell phone records. Courts still enforce it. Religiously. Even when justice seems to demand otherwise. But wait. Think about this differently. You are on trial for murder. The only evidence against you is testimony from someone who claims their friend told them you confessed. But that friend is not in court. You cannot question them. Cannot challenge their memory. Cannot expose their grudge against you. Cannot ask why they are not present. Now suddenly, the hearsay rule does not seem so unreasonable, does it? This is the genius of the adversarial system. Every statement should face cross-examination. Every witness should answer for their words. When Sandra named her attacker, her statement was hearsay. The neighbor could repeat it. But Sandra herself could not be questioned about her certainty, her consciousness, her ability to see clearly. And prosecutors had no way to satisfy that requirement. The dead cannot testify. So the hearsay rule exists to protect the innocent. But what happens when it protects the guilty? 2004. A young woman in Texas is stalked for months. She tells friends, co-workers, family. She names the man terrifying her. She documents everything. Then she vanishes. Her body is found weeks later. Police arrest the stalker she identified. And prosecutors face a nightmare. Every single statement she made about her stalker is hearsay. The victim herself cannot testify. The very person who knew the truth best is permanently silenced. The defense files motions to exclude everything she ever said. Every warning. Every fear. Every accusation. And this brings us to the most controversial question in evidence law. Do the rules meant to protect defendants sometimes guarantee killers walk free? But that is not even the worst part. Centuries of lawyers saw this problem coming. So they carved out exceptions. Dozens of them. Dying declarations. Statements made believing death is imminent can be admitted. Business records. Documents kept in ordinary course of operations. Excited utterances. Words spoken in shock before the brain can fabricate lies. Present sense impressions. And here is where your case lives or dies. Whether your evidence fits an exception can determine if a murderer serves life or walks free. That Texas stalking case. It came down to one exception called forfeiture by wrongdoing. If the defendant caused the witness to be unavailable through their own actions, they forfeit the right to complain about hearsay. Subscribe now because what happened next changed everything. The Texas prosecutors argued brilliantly. The stalker killed the victim specifically to prevent her testimony. He forfeited his right to object. The court agreed. Every terrified statement she made came flooding in. Her own words convicted her killer from beyond the grave. 25 years. But here is where it gets even more complex. What about text messages? Emails? Social media posts? In modern trials, these create absolute chaos. A text message saying "I am scared of John" could be hearsay if offered to prove John is dangerous. But that same message might be admissible to prove the sender's state of mind. Same words. Different purpose. Different ruling. Defense attorneys have turned this confusion into an art form. Every digital breadcrumb becomes a battlefield. And coming up, the single case that shows exactly how prosecutors lost everything because of one hearsay ruling. 2016. A brutal murder in a small town. The victim's friend testifies that the victim called her the night before, terrified, naming the killer. The prosecution builds their entire case around this statement. Excited utterance, they argue. The victim was clearly in shock. The judge disagrees. The phone call happened hours before the murder. Plenty of time for fabrication. The statement is excluded. Without it, the case collapses. The defendant walks free. The victim's family watched a killer go home because their loved one's final warning did not fit a legal category. And this is the answer to our opening question. Why silence a dying woman's truth? Because the alternative, admitting anything anyone ever said, creates more wrongful convictions than it prevents. The hearsay rule is not about truth. It is about reliability. And sometimes, reliability and justice are not the same thing. So where does this leave us? The hearsay rule will never disappear. It evolved from corruption. It protects defendants. It ensures confrontation. But courts are adapting. 23 states now have laws specifically addressing statements by murder victims. Federal courts increasingly recognize forfeiture by wrongdoing. Technology is forcing new exceptions. The ancient gossip law still controls modern trials, but its grip is loosening. Now you understand why courts ban what everyone already knows. The question